I'm Judge Joel Clouser, and I've been the Justice of the Peace for 25 years. And this is Precinct 2. Are we ready? Yes. All right, welcome. Welcome. All right, now how many landlords do we have in here? Please raise your hand. Oh, we got a lot of landlords, huh? How many property managers? How many people who manage property? Okay, good, good. Now tell me this. How many tenants do we have? Tenants, okay, welcome, welcome, okay, welcome. You, and you should be here because we're going to talk about tenants' rights too. I'm a Justice of the Peace, and my office, we collect money, and we also try cases. Now, the Justice of the Peace, we have a criminal docket, and we have a civil docket, just like other courts, even the county court at law and the district court. Now, our criminal docket consists of non-jailable offenses. The most notable is the traffic ticket. And that's the kind of crime you commit, they don't take you to jail. Only way we can take you to jail if you don't show up in court, or if you're fined and you don't pay your fine. Now, we also have a civil docket. Now, our civil docket consists of debt claims, and that's where somebody gets sued for credit card debt. Small claims, that's like Judge Judy. Judge Judy goes up to $5,000. We go up to $10,000 in the state of Texas. And we also do evictions, and that's what we're going to talk about today. We do repair and remedy cases, and we're going to talk about that too. That's one of the tenants' rights. Now, evictions. In evictions, time is of the essence. Time is of the essence. We've got to hear those cases real quick. There's laws that govern how soon we must hear those cases. Now, an eviction case is a suit for possession. A suit for possession. I should back off this thing. And you can join a suit for back rent and court costs. And if you have any attorney's fees that are applicable. Did I go backwards? Have I got this thing backwards? That's embarrassing. All right, there we go. Now, grounds for eviction. Now, 90% of my cases, grounds for eviction is non-payment of rent. That's the major ground for eviction. And most of you, when you come into eviction court, it's mostly for non-payment of rent. Then also you can evict somebody because they don't pay the late fees. Also because if it's in the lease, they're supposed to pay utilities. They don't pay the utilities. That's grounds for eviction. That's some major grounds for eviction. Those are the major grounds for evictions. The next major ground for eviction is pet violation. So most leases have a pet clause, and it says that if you're going to have a pet, you got to pay a pet deposit. And sometimes landlords go out to the house and they knock on the door to collect the rent, and they hear a dog barking. So that's a grounds for eviction. Also, crime of moral turpitude. There's fraud, theft, perjury, tax evasion, unlawfully carrying a weapon, disorderly conduct, things of that nature. And the next ground is destruction of property. You go out there and your tenant is tearing the place up and it upsets you. And that's a grounds for eviction. That's one of the grounds for eviction. Then you got the neighbor from hell. And I don't know, has anybody ever had the neighbor from hell? Okay, thank you. And also now, a new one, prostitution. This is a new one. So if somebody is practicing prostitution, is that the right word, practicing prostitution? Did I use the right word? Okay. The pimp who has his girls living in your rent house, okay, you can evict them. All right, and now, month to month, this is another grounds for eviction. They're month to month. You want them to move, all you got to do is give them a 30-day notice. The lease is expired, or there's no lease. They're on a month-to-month basis. Just give them a 30-day notice. And also, violations of deed restrictions, covenants, and city ordinances. We have landlords who come in, the tenant won't put in the garbage can, the tenant won't cut the yard, and the city of Missouri City, I don't know, does anybody live in Missouri City? Okay, city of Missouri City will fine the owner, not the tenant. They fine the owner. Owner's upset. Owner goes out, knocks on the door and says, you got to put the garbage can in. And the tenant says, I'll put it in when I feel like putting it in. Grounds for eviction. Also adverse possession. I don't know if many of you are familiar with this. I know in the inner cities they have a big problem with this. You got homeless people. They roam the streets. They see a vacant house. They notice this house has been vacant for a week. They break in, they start living. And you come along, you just happen to, come along, you check on your house once a month, and you find somebody's living in it. It's called adverse possession. And back in the old days, ranchers had to ride the range at least once a year to make sure, when they had 5,000 acres. Y'all remember Bonanza? Oh no, come on, don't deny that you're that old, please. Huh? Y'all remember Bonanza? Okay. And you remember Pa and the boys used to ride the range. And they rode the range because they wanted to make sure there were no squatters. If you let them live there long enough, they can claim adverse possession. So you have to ride the range and tell them to get off my property. Okay? So same thing here today. You got homeless people. We had a case where a man broke in a house, started living, and the landlord tried to evict him, and he said, adverse possession. And he said, I've been there over 5 years. He knew the law too. I've been there over 5 years. And I said, but show me your tax receipts that you paid the taxes. He couldn't do it. So I evicted him. All right? So y'all understand that. All right? It's exciting. This job is exciting. I'll tell you. Just when I think I've seen everything. Continuing with grounds for eviction. A lot of mistakes landlords make is they fill this thing out. They fill the petition out, or they half fill it out. They don't completely fill it out. Okay? Now, it's important that the petition be completely filled out. And we're going to go through each section of the petition. Okay, this is the top of the petition. Now, folks, property managers. Some property managers come in here and they put their name as the plaintiff. And when you fill out this petition, the plaintiff is claiming they have superior right to possession of that property. When the property manager puts his name, or they may have a friend, somebody, a non-attorney, can represent them. And they may have a friend, they may be out of town, they've authorized a friend to represent them. And that friend puts his name up there as plaintiff. And what that means is that if he gets a judgment, the defendant tenant has to pay him the rent. And he's not entitled to the rent. Okay, so that's a major mistake they make. Okay, you have to put in the amount of the rent, monthly rent, the complaint, because this is going to be attached to the citation that's served on the tenant. And the tenant, is only fair that the tenant knows on what grounds you're trying to evict them, so they can prepare a defense. So you must complete it. You must complete it. Here, non-payment of rent, unpaid rent, the amount of the unpaid rent. Also, if there's a pet violation. Also, the fact that the notice to vacate was given. You've got to give them a notice of vacate, the date of the notice to vacate. We need to know about that. And also, you've got to sign it. If you are the agent you must circle agent. If you are an attorney, you must circle attorney, okay? If you are the plaintiff, you circle plaintiff. Let us know you're the plaintiff. And also the address where we can send the judgment. All right, common mistakes landlords make. Property managers and eviction companies. You know, there are eviction companies, and they're in the business to just represent you in an eviction case, right? One of them, Evictions.com. They don't own the property, but they come in and they put Evictions.com versus John Smith. They put themselves in as the plaintiff. Now, if you're not the owner of the property, if you're the property manager or you're an eviction company, you must put the name of the owner of the property. Okay? You're just representing the owner. Also, you must have some type of written authorization. It does not have to be signed in front of a notary, but just give us some indication that the owner has given you permission or has requested that you represent them in court. Now, both parties can be represented by or have a representative who is not an attorney. I want to let you know that. The tenant can be represented. Last month I had a lady in and she was representing, I don't know who this guy was. He said, I'm representing her. She has laryngitis. And then he put her on the stand and I didn't hear laryngitis at all. And so he was representing the tenant. And he has a right to do that. He even showed me a power of attorney. But when he stood up in front of the jury and he said, you don't have to pay rent if there's no lease. See, the lease wasn't signed, so you don't have, that's the law. That's when he said, that's the law. I said, sit down. He was misrepresenting the law. Okay, you make sure you file it in the proper precinct. The precinct where the property is located, the county and precinct where the property is located. And you must file against each person on the lease. Now, we got a lot of landlords and property managers who try to save money. But let me tell you what happens. If you got Mary Jones and John Jones in the house and you just file against Mary Jones, Mary Jones is the only one that can be evicted. All right? And so John Jones stays in the house and invites Mary Jones back as a guest. All right? So you've got to include everybody on the lease that's listed on the lease. Now you can say all occupants, but you've got to list everyone who is on that lease. You got to pay the money. If there's 3 people on the lease, what is that? I don't set the court cost, but what is it, $260 something dollars?
$126 plus 80 per extra person.
Okay, all right, you do the math. All right, but you got to pay it. All right, if you want to do it right. Okay, now you must bring a copy of your 3-day vacate letter in the event the tenant says, I did not receive the vacate letter. You must give them a 3-day vacate letter before you file. You must. It's a must. It's the law. Very seldom do we have tenants who question that, but I've had some tenants who did question it. Now, I'm not giving you legal advice, but we had one landlord who posted the 3-day vacate letter and took a picture of it with a cell phone. I don't know, whatever you want to do. And when the tenant questioned it, she took out her cell phone and she showed me the photo in the cell phone. That was good enough for me. Thank you. All right. Now, you cannot physically throw out a tenant. You can't do it. I know of a landlord. No, I tell you what, I know of a landlord who took the doors off the house. Took the front door off. took the locks off the garage door. It was an attached garage. Took the door leading from the garage into the kitchen off. And it was in February. It was cold. The tenant comes home from work and sees this and thinks someone broke in the house and calls out the constable. And the constable does a welfare check, goes through the house and to make sure no one's in it. Well, she ended up spending the night on the sofa in the living room to make sure nobody came in, and it was freezing. All right. So you can get in trouble for doing that type of thing. All right. You can't throw the tenant out yourself. Now, I'm trying to, and you can't cut off the utilities, folks. You can't cut off the utilities, and we're going to get into that. Okay, there we go. Additional common mistakes. The property manager or the eviction company representing the landlord or the owner of the property is not knowledgeable of the landlord-tenant history and relationship. Okay, the property manager and the eviction company, sit down with the landlord so you can get some detail, because and just learn the history, because the tenant might come in and say, well, the landlord said he was going to do this. The landlord said, well, the property manager doesn't know anything about it. Also, communicate with the landlord or the owner about whether or not the day before court, whether or not any money has come in, because many times the tenants come in and they say, oh, I sent that money last night. So just kind of your word to the wise so you can be knowledgeable. Folks, the lease rules, all right? Okay, what's in that lease? That's what really rules. I want you to read it thoroughly. If you're a tenant, read it thoroughly. If you're the landlord, read it thoroughly, okay? It's going to give you the term of the lease is usually 1 year, what the monthly rent is, when it's due, and if it's not paid on time, the late fees involved. And the landlord, usually at the beginning of a lease, the landlord collects 1 month's rent in advance plus the security deposit before the tenant moves in. Now, we have tenants that say, I gave him the first and the last month's rent. That's not true. You gave him the first month's rent and a security deposit. The security deposit is usually in the amount of 1 month rent. Okay, that's the dollar amount, the amount of 1 month's rent. Now, there are exceptions. If you got a tenant who's a high-risk person, that is, they've been evicted before, and usually it's you can find that in the credit, when you do a credit check. Also, the Houston Apartment Association keeps a journal on that, on people who've been evicted before. Sometimes the landlord will insist on 2 to 3 times the amount of 1 month's rent. All right? Now, the security deposit is not to be used in lieu of rent. Is not to be. That's the law. So the tenant cannot say, well, he's going to use my last month's rent. Well, you got the security deposit, use it for the last month's rent. You can't, all right, legally you can't do that. Okay, it's to cover damages due to the negligence of the tenant upon move out, not normal wear and tear, but due to the negligence of the tenant, okay, or the tenant's guess. Now the tenant can't say, well, I didn't do it, but one of my friends did it. Well, the tenant is responsible. Now, upon move out, the tenant must give, let's say 30 plus or minus days notice of move out. Sometimes we just don't, 27 days, 28 days, something like that, but close to 30 days notice. And for tenants, I want you to know this. You want to get your security deposit back when you move out. You want to give about a 30-day notice that you're going to move out. You give a walkthrough. It's wise to give a walkthrough. to the landlord or the property manager, then you must give the landlord or property manager, a forwarding address in writing, where you're going to move to. So the landlord has 30 days to give you a refund of your security deposit or a list, itemized list of what they had to fix due to your negligence, and then the remainder of your security deposit. Okay? But you're not entitled if you're behind on the rent. So you must be current on your rent. So the solution is never to withhold rent. That is not the answer if you have a problem. We're going to talk about the answers you got. All right? Now, pet clause. And like, you remember I mentioned that to you. That's another reason for eviction. If the tenant has any animals, cats, dogs, snakes, and boa constrictors as such, you must inform the landlord and pay a reasonable pet deposit, because animals do cause damage to a rent property. Okay? If there is no lease, how can the lease rule? Well, the Texas Property Code rules. Chapter 92 of the Texas Property Code. Okay. Now, if the lease has expired, the terms of the lease still are in effect. They still rule. The only disadvantage for the tenant now is the landlord can give you a 30-day notice to vacate. So it's to your advantage if you wish to stay to sign that lease. Here's the eviction process. The eviction process. First of all, remember I mentioned, you've got to give them a 3-day vacate notice. Now you can give it to them in person, you can mail it, or you can post it on the door. Like I said one time, a tenant questioned it and said, I never got a 3-day vacate notice. And the landlord produced a picture on the cell phone, and I will accept it. I don't know if other judges will accept it, and showed that it was on the door. Nowadays, in this electronic age, they're saying stuff over the internet is considered sent, or something like that. You send it email, it's considered sent. I would be very careful, because the tenant might say, I never got it. Okay. It might be best just to go out there and you post it on the door, post it on each entrance. Might be best. On the garage door, on the front door, and then you might have a witness. Keep a copy and have the witness sign that they witnessed you doing it to be safe. I know some landlords have done that. Okay, so they can't deny it. Yes, sir. Oh, you can send it certified mail. Yes, sir.
The 3 days notice, does it has to be inside the main door or?
Yeah, that's what they said, but they relaxed that because sometimes the screen door is locked and you can't put it inside. So, yeah, you can't get access. Yes, ma'am.
You can put it on the outside of the front door as long as you put it in a sealed envelope and state important document.
Important document,
and
okay.
then mail it before 5 p.m.
You come on up here and do this. Yeah, I'm telling you. That's true. Yes.
I post mine on the front door, the garage, the windows.
All the doors, huh? You make sure.
Mailbox, and I make sure it's a loud color so everybody know they got it.
Okay.
I always write on mine, access to inside of the front door unavailable.
Okay, that's good. Protect. Yeah, but they kind of relax that. The tenant dies inside the house, okay, and you can't find the next of kin. That does happen. All right, but you want to get the stuff out so you can fix your house up and re-rent it. But you gotta try to post it for 30 days. Try to post it in the newspaper looking for next of kin. Oh yeah. Well, if the executor of the estate, they're in charge, and you can evict the estate.
Okay, do they have access to my property?
You gotta
They're
go
not
to,
on the lease.
I know, but that person has died. Now they have an estate and they have an executor. Okay, so that executor now has the same power as the decedent. So
So
you,
that executor would have to be.
you can evict the estate of your tenant. If they file for bankruptcy, if they file before the eviction process or during the eviction process, I've got to stop it. If I have made a ruling, already, you can file for your writ of possession. But if before the process is, before we go to court and we go through the court process, I've got to put that case on hold and give you a chance to go to the bankruptcy court, and they will release the property from the bankruptcy. They will. They always do. If it's rent property, they release it. But you got to go to court and you go to the bankruptcy court. Now, the tenant has to show me that they filed bankruptcy, and I'll put your case on hold until you do that. And you can ask for an emergency hearing before the bankruptcy judge and get the property released, and we'll proceed. All right? You understand? You got to file it in the county and the precinct where the house is located. The service of the citation is by the constable, and they can personally serve if they refuse to answer the door. A lot of times the tenant looks out the blind and sees it's the constable and refuses to open the door. A constable can also post it, all right? And they have to post it or serve it at least 6 days before the trial date. The trial will be held no less than 10 days or more than 21 days from the file date. That's the window. Now, the parties have the right, either party has a right to a jury trial. Usually it's the tenant who asks for the jury trial. They have to pay $22 for the jury fee. They can file with the SIP, and that is a statement of inability to pay. Everybody has a right to do that. All right? They can claim to be a pauper. And the Texas Supreme Court and has relaxed the rules on who is a pauper.
How long after posting it? Like, is there a time frame that you have to come in to have that notice still be relevant?
That would be, if it's questioned, if it comes into question, if the tenant questions it, say, hey, gave me a 3-day notice two months ago.
So it's not no good after 2
We
months?
might-
It would be good, wouldn't it?
Well, it's got to be a reasonable period of time. Or if it's 2 months ago, maybe you should give them another 3-day notice. It depends on the discretion
I mean,
of
if
the
it's
judge.
2 or 3 weeks, that's going to be a reasonable frame of time to come file.
I don't know, I'd have to hear the other side of the story. If the tenant does not show up, then it's a default judgment. If a landlord doesn't show up, it's dismissed. Usually we dismiss it without prejudice, which means maybe the landlord missed the court date and can come back and refile. Okay? Now, once the judgment is rendered in favor of the landlord, the writ of possession shall issue the 7th day after the judgment, on the 7th day after the judgment. But sometimes landlords will hold the writ of possession. They'll try to hold it over the tenant's head and say, okay, I'm going to file this thing, you better pay me my rent. A lot of times landlords feel like, well, I'd much rather they pay me than kick them out and have the property vacant. And so they'll hold it over their head. I have a user-friendly court, and you don't have to hire an attorney. Well, I like to say, we always recommend you hire an attorney, but this is a user-friendly court. And they put it in writing, they wrote it on a notebook piece of paper, said, I paid, now the landlord is trying to get me out. And I hold a hearing on that. Well, if I find out the tenant has paid, then of course they're going to have to refile if it was not included, if that particular month was not included in that judgment. They're going to have to refile. Now, the writ of possession must be used before the 61st day. You got 60 days to use it. Now, after 90 days, it's no good. The tenant has a right to appeal. That's the wonderful thing about our country. Any judge's decision can be appealed. Now, in the JP court, you can appeal, the tenant can appeal on up to the county court at law. The appeal must be filed within 5 days of the date of the judgment. The tenant must file a notice of appeal in writing. They can just write out, I wish to appeal my decision. Now, the tenant must post an appeal bond within 5 days of that notice, and usually the appeal bond is twice the amount of the judgment. If there's no judgment, we set an appeal bond which we feel would be reasonable if there's no judgment for back rent. I'm sorry, when I said if there's no judgment, I mean if no judgment just for possession and not back rent and court costs, we usually set a reasonable bond. Now, what is happening a lot now is the tenants will file an appeal using the SIP, what we call appeal as a pauper. And they'll fill out the SIP. That's a statement of inability to pay. If the landlord wishes to contest it, then we hold a hearing. We hold a hearing real quick within 5 to 7 days on that, on the contest. Now, let's say if I rule that the tenant is not a pauper, the tenant has the right to appeal that to the county court at law, and they don't have to post a bond. Just want to let you know that. So most landlords will not question it. Now, if they filed with an SIP, they've got to post 1 month's full rent in the registry of the court within 5 days of giving the notice of appeal. And we let them know that. We let them know that, okay? And that's given to you in writing. You know what day you have to post the 1 month's full rent. If you don't post it, your appeal is denied. You have not perfected your appeal. And the landlord can immediately file for the writ of possession. The writ of possession is an order to have the constable remove you from the premises. Now, 1 month's full rent, if you filed with an SIP, you must post 1 month's full rent. Now, usually it takes about 2 months for an appeal to be heard. And you must post 1 month's full rent the first of each month in the registry of the court. 1 month's full rent, all right? Now, and in the county court at law, they're going to send you a letter telling you what the court cost is. And you're going to either pay the court costs. If you don't pay the court costs, they kick your case out. Now, you can use an SIP, Statement of Inability to Pay, in the county court. I don't know what the details are on that one. I don't deal with the county court at law. There are laws to protect tenants, and it's very important that landlords, property managers, people who represent the landlord know what these rights are. What we do is usually that when they deposit the 1 month's rent, it's usually in the form of a money order, a cashier's check, usually money orders. And we just send it on up to the county court. We let them deposit it.
And if they don't, on the 5th day, the next day,
That's it.
you can get you a writ.
The appeal is not perfected, you can get your writ of possession. As a matter of fact, when we hold that hearing and they haven't, you can immediately, the writ shall issue immediately. You can just go to the window and file for your writ.
Okay. A hearing on,
Well, if, let's say for example, they file as an with an SIP, and you want to contest it. We hold a hearing. We probably hold a hearing with it. Let's say if they file on a Thursday, we'll hold a hearing on a Tuesday. We got to hear it as quickly as possible. Remember, time is of the essence. Okay. And if that Tuesday, they were supposed to post the rent on that Monday, let's see, what, 5 days? Okay, let's say. Okay.
Yeah, that would be.
Okay, Friday, Saturday, Sunday, Monday. Well, I'm sorry.
You count weekends in that situation?
Yeah, we do. Saturdays and Sundays in the eviction
The
cases.
first day is counted?
No, well, when they file the notice of appeal, then they got 5 days after that.
After that?
Yes,
So the next
yes.
day is starting to count?
Yeah, yeah, okay. And so if they haven't done it, then the appeal is not perfected.
After the day that they
Yes.
file those. Okay, one other thing I wanted to say about repair and remedy, just a word of caution.
Yes.
Because if you try to evict somebody because they filed a repair and remedy.
Yeah, that's retaliation.
That's.
Yeah, you can't do
I wanted
it.
to say something about that.
Yeah, okay. I'm glad you reminded me. I should have said something about it, and thank you very much. So once they file the repair and remedy, you can't file eviction in retaliation. You can't do it until after it's heard. Now, if you've already filed eviction, they can't file repair and remedy. That's retaliation, huh? And they cannot be repair and remedy. Okay, you remember I talked about repair and... I'm sorry. Okay. Yeah. Let's say if it's a condition that materially affects the health or safety of an ordinary tenant. Okay. And remember I said the tenant, the answer is not to withhold rent. But and if the landlord, you got to give the landlord 7 days, which we consider reasonable to fix it. All right? And if the landlord does not fix it, you can file a repair and remedy case against the landlord.
Okay, I want to ask you a question.
Yes.
In my leases, I have in there that the first $150 on any non-repairs, you have $150
Sure.
copay. If you cause the damage, you're 100% responsible for the entire amount of the damage.
Is that what you have in the lease?
Yes.
Okay.
Anytime.
Okay.
And so, don't they have to pay for it if I send somebody out? Aren't they responsible for paying?
If that's in the lease rules. If they sign that lease, the lease rules. It rules. Okay. Yeah. Normally, it's they pay the first $150. Okay, $150. Not.
The damage, I make them pay it out.
Okay. If they sign that, that's fine. It rules if they sign it. Okay. All right. Now, we talked about rid of re-entry on the lockout and what the penalties are. We talked about the security deposit. You have 30 days to refund the security deposit, but they must give you a forwarding address in writing where you can mail it. You got 30 days. Now, either you're going to refund the entire amount or you can deduct for repairs that have to be made due to their negligence or the negligence of their guests. Okay. Now, a lot of times the damages are more than what the security deposit is. So if you wish to get that, you're going to have to be able to sue them in small claims for the additional amount. Writ of retrieval. Now this is, yes ma'am.
Does the 30 days start to run when not, it doesn't start to run until they give you that address, right?
No, it doesn't. It runs when they give you that address. If they never give you that forwarding address, you don't have to until they give you the forwarding address. They got 30 days from the time they give you that. The answer to tenants is not to withhold rent, because if you withhold rent, it kind of bars you from your rights if you withhold rent. Repair and remedy. Now, we get tenants who come in and say, I'm not going to pay rent because this is wrong, that's wrong, that's wrong, okay? You can't withhold rent. You can't do it. Now, if you feel it's a condition that materially affects the health or safety of an ordinary tenant, you can file, it's like a small claims, a repair and remedy case against the landlord. Now, the only situation, the only condition is you can't be behind on the rent, and it's got to be a condition that materially affects the health and safety of an ordinary tenant. I will hold a hearing on it as quickly as possible, and I will make a decision as to whether or not the landlord should make those repairs. One of the penalties if the landlord does not make the repair or remedy is 1 month's rent plus $2,000. The penalty is heavy. So you want to make sure that you make those repairs. Also, the tenant has the right to appeal. We've already talked about that. And then sometimes the landlords, they had a landlord one time, he went and cut off all the breakers. And then he locked the breaker box and put a lock on the breaker box. So now, you cannot interrupt the utilities. The tenant came in, filled out an application to restore the utilities. I immediately issued an order to have the landlord take the lock off and cut back on the utilities. Now, there's a penalty. Now, I can put the landlord in jail, hold him in contempt, put him in jail until he says uncle, until he cuts back on the utilities. I can do that. Also, there's a penalty of 1 month's rent. And so that's something you don't want to do. So if the tenant is behind on the rent, it's best to go on and file your eviction case, but don't cut off the utilities, right? The only reason you can cut off the utilities if you have some construction going on and you have a reasonable period of time. You got to let the tenant know that you're going to have the utilities cut off while you make the repairs. Some landlords lock the tenant out. You can lock the tenant out, but you got to post where they can get the key 24/7. And first of all, the landlord has to bring them the key. Once they, a telephone number they have, then once they call that number, you have to post it. And you post the telephone number, and once they call that number, I don't care if it's 3 o'clock in the morning, then the landlord has 2 hours to bring them a key to let them back in. Now, you say, why lock them out?
Yeah.
That don't make no sense, does it?
But
Huh?
why do you have to let them in if you lock them out?
Did y'all hear that? That's what I asked. Okay, now, why lock them out if you're going to give them the key? Now, generally, the reason for that is because the tenant will not communicate with you, won't call you back, is dodging you, and won't pay the rent. So you want to lock them out to get their attention so you can talk to them and say, hey, you going to pay me my rent? That's the reason. But you got, if residential lease, you got to give them back, give them a key, a new key. All right? Now, let me say
If they
this.
haven't paid you, you still have to give them a key?
Yes, you do. Yes, you do. You can't do that.
I was asking. I was asking. Even if they haven't.
There's a heavy penalty for that. We're going to get to that. All right. Now, first of all, you got to come out. You got 2 hours to bring them the key. I don't care if it's 3 or 4 o'clock. Now, some tenants will play games. You get there, in 2 hours, they disappear on you, and they laugh. I made you make a trip. All you got to do then is put up a sign saying, I was here at 3:05 a.m. in the morning on such and such a date. Now you can come pick up the key. And you tell them where they can pick up the key. It's up to them then to come and pick up the key. All right? You all understand that? All right. But you made the effort to come out in 2 hours and bring them a key. All right. Now, if you don't, if you lock someone out, and we had a situation where a landlord locked them out, didn't put up a sign saying where you could get the key, and she was outside the house, she had to break in. The penalty is 1 month's rent plus $1,000. So you don't want to You want to make sure you provide that, put that sign up, tell them where they can get the key, all right? And you might just take a picture with your camera so the tenant won't say, he didn't post that sign. And it's so easy, you know, to do that. Everybody has a cell phone with a camera on it, so you might protect yourself.
You've given them the 30-day notice, but they've actually moved with everyone's, even the neighbors have said
They move.
They give the key back.
You got to be,
still have to.
and okay, if they don't give you the key, they still have possession of the property, so you can't get in it. But let me say this, be very careful. They may have some belongings in the back, and they may claim you walked in and took the mink coat and the $10,000 diamond ring. You got to be very careful about that. So seek the advice of an attorney on that one. Writ of retrieval, this is not an eviction issue. But I just want you to know about it, because sometimes we have a situation where a lady is living with a man and he gets mad at her and he runs her out the house and he says, I don't want you to come back. And he's got all her clothes, her toothbrush, he got the children's backpacks and books and the whole works. She can come in and she can file for a writ of retrieval. Okay, this is not a landlord-tenant situation. This is mostly a boyfriend-girlfriend situation. Or it could be a relative has moved in with you, and the relative said, I'll only be here 1 week, and ends up staying 3 months, and the owner of the house says, I'm sick of you, and locks them out. Okay? Now, they can come in and they can request or fill out an application for a writ of retrieval. And they want to get their personal items out. They want to get their clothes out. I can sign an order. I will hold an ex parte hearing, talk to them, they fill it out. And that is, I can sit down, I don't have to have the other side here, I can sit down with them, and they must list everything they're going to get out, and the constable will give them 30 minutes. The constable will call the owner of the house and say, you got to let us in so they can get their personal items, so they can get the children's items out. And if the owner of the home refuses to do it, then the constable can break the door in and escort them in and give them 30 minutes to get their stuff out. All right, this is not a landlord-tenant situation. A lot of times, senior citizen communities, okay, they give you some type of special concessions on the rent, or they give you a great senior citizens deal. And they want to make sure you don't move your kids in and your grandkids in. And they have a right to do that. And they can just say, okay, like for example, there's a subdivision, Country Place. Y'all familiar with Country Place in Pearland? And it's 55 and over. And if you want to have your grandkids come over for the weekend, you got to sign them in, and you got to sign them out on Sunday. Now, if it came into my court, I'd want to see the lease. All right. I'd want to see the lease. You might let them know something in writing, that you having a nephew come in, going to stay 7 days. All right. So seek the advice of an attorney. The lease expired. You don't have a lease. And when it expires, you just send them a letter, 30-day notice that you're going up on the rent.
Yeah.
That's your right.
54 days notice. Lease is only 30 days. We give her 54 days notice. So we don't renew. If you want to stay, you will have to pay high rent.
You gave them notice.
High rent.
Seems fair to me.
So is she going to pay high rent or she stayed? She said, because Harvey, she could not find a place to live.
You just jack the rent up, man. If you give a notice, you jack the rent up. If the lease is expired, you jack the rent up. You're within your rights as long as you give them notice that it's going up. All right?
Well, I got
Yes, ma'am.
I think it's very unfair though for landlords to jack up rents during Harvey because people are already been displaced, some of them having trouble, but couldn't go to work or what have you. And some landlords were taking advantage of people telling them that they're gonna, because FEMA was offering this a really great amount of money to for them to rent out their houses, and so they were trying to get people to just get out of the lease. And I know this for a fact that my neighbors were given text messages saying you need to get out of the property because unless I'm going to jack up your rent $500.
It's been my experience, most landlords have been very reasonable. They really try to help tenants out. It's been my experience. It has been my experience. That's been my experience, so I'm just letting you know. But tenant has a right to vacate and break the lease if they've been the victim of a sexual offense, stalking, or domestic violence. You got to have a police report. You can't just walk up and say, I've been raped, or there's some guy stalking me, some weirdo. You got to have a police report. You can't just do that. Now, military deployment, of course, you're going to have documentation of that. And they have the right to vacate and break the lease. I get some tenants to come in and say, there's mold in that house. Mold in that house. I'm coughing. You know, in Houston, Texas, in this humid, the humid weather we have in down here in the southwest Texas, we're close to the Gulf and the humidity is real bad. You're going to have some mold in every house, or a lot of houses. You're going to have mold in a lot of houses. It's got to be bad enough where you have a mold expert. It's got to be an expert, certified expert, evaluating the house and saying it's that bad in writing. And then you really need to have a doctor's evaluation to say that the mold is really making you sick. The landlord, if he has other units, can move you into another unit, a comparable unit, and let you live out your lease. If it's partially habitable, you'll find most landlords are nice enough to give some concessions on the rent, on the monthly rent, until they get it fixed. Now let me say this. In this atmosphere of the hurricane, the tenant must wait, must give the landlord a reasonable period of time. That reasonable period of time really doesn't start until the landlord receives his insurance check. Okay? And you also have to consider the fact that there's a scarcity of plywood, 2x4s right now, because everybody's buying out Home Depot and Lowe's. Okay? So you got to give them, so the landlord has to give you notice of the reason for the delay on making the repairs. You understand that?
Judge, you did say that if the apartment or the house is unlivable, that the landlord is supposed to refund them their deposit back.
Yes, break the lease, yeah. You do not attempt as a landlord to move your tenant out. Do not do it. You can be sued. The constable cannot be sued. So you file for your writ of possession, and the constable, first of all, our constable gives a 48-hour notice that they're coming out with the trucks. It takes them about a week. It takes them about a week to arrange for the move out. They have a backlog. The landlord must provide 2 or 3 strong men. The constable will supervise the move out. If the tenant does not open the door, the constable has a tool that breaks open the door. And they go in, they move it out room by room, and they set it on the curb. They used to take it to a bonded warehouse, but all the people who had bonded warehouses, they went out of that business because they couldn't make any money. So in 31 days, they'd sell the stuff, and a lot of it was considered to be junk. They really couldn't get their money's worth out of it, so they went out of that business. So the law allows the constable to put it on the curb. And also the landlord, and allows the landlord to secure the property, change the locks, lock it up, board it up, whatever it is to secure the property. It ain't pretty if the tenant gets put out. So if there are tenants here and it's time for the move out, a lot of times the constable will, the officer or the deputy who's in charge of that will come by and knock on your door and say, "We coming out in the morning." So it might be best to move your stuff into storage because it ain't pretty. Once they put it on the curb, you got to worry about your neighbors.
Have you had anybody get tenants arrested that got in there? I mean, not tenants, but people who've broken back in and stuff.
Yeah, that's trespassing.
Have you had
Once they've been evicted and they break back, yes, I had that to happen one time. And then you can call the police.
But the
Well,
police won't do anything. They say, that's a civil matter, and then you have to go
No.
through.
Okay, contact the constable. The constable knows they've been evicted. That's trespass. They'll take them to jail. They've given them a trespass warning. Do not come back on the premises. Okay, if you cannot afford an attorney, Lone Star Legal Aid will help you. Okay, they are funded by a grant, and they will help you if they feel your case has merit. Now you got to understand they have limited resources, so they may sit down with you to see if your case has merit. All right, and they may take your case, they may not take your case. So I can't say.
I'm Velma,
I'm Sharon Ratcliffe.
and I came to this court because I am a landlord, and I did learn a few things I didn't agree with, but in all, it was very informative.
Yeah, it was very informative. I learned a lot of things that I didn't know. I'm first-time landlord, so yes, I'm learning about things I didn't know before. I didn't realize that tenant had all these rights and what have you. I was just wondering if the tenant wrote all the rules and regulations. I don't know, but it's it's really informative. Yes.
I'm Sam Cherian. I live in Harris County. I'm a realtor, but I love this class. It gave a lot of information for the tenants and the landlord. It was a good experience to spend 2 hours over here. That gave me a lot of knowledge. Thank you.
Okay, I've learned so much attending the tenants and the landlord's rights. And basically what I've learned is my rights as a tenant in a senior development has been violated. And I'm learning more and more whereby the lease, which I do examine, and I'm up for renewal, that I am going to require to get assistance to help me through my disabilities. And so by coming to the workshop and listening and taking in the input is fantastic. The questions are appropriate. And the networking is amazing. So I have someone who will help me with my problem, and I didn't even know that they were listening to it, but they found the question about the limitation of visitation very, very prominent, and I appreciate that. So my nephew can come and visit me.
My name is Amir Keparia, and this presentation by the judge was extremely helpful, and I appreciated getting the email to be present here. Thank you.